Lawyers of Reddit. What was the best gotcha moment you ever experienced? Story 1. My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about $1.2 million. Then I get involved. During a deposition with the claims adjuster, I asked how she concluded that the storage tank was not a part, or at least connected to, the heater. She states that she relied on her quote-unquote expert witness who was an engineer. Little did she know I had already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. Her little admission cost the company about $500,000 in fees, on top of the original claim of $1.2 million. And this is why so many people try to screw insurance companies, because they're right there, trying to screw you too. Story 2. I had a former client file for bankruptcy, and in connection with that case brought an action against his landlord for violating the automatic stay. To prove damages, he wanted to show he paid my firm for legal fees in connection with the landlord's pursuit of rent in violation of the stay. So this former client's bankruptcy lawyer serves me a subpoena to show up at the bankruptcy hearing. He didn't ask me any questions prior, but just gave me the gist of what the objective was, i.e. verify with the court the time I spent and the cost to his client. The bankruptcy attorney called his client, my former client, to the stand first. He asked him questions related to his hiring my firm to do this, and that it is related to his landlord. Apparently that's not enough. The bankruptcy attorney wants me to verify these facts as well. I get put on the stand and I'm asked to verify the invoice. I first object to the question as a precaution since it may be a violation of attorney-client privilege to answer the question, and to cover me for any claim by the bar or my former client. As predicted, the judge overrules and orders me to answer. I review the invoice and answer, "No, this is not my invoice." His attorney, "I don't understand. This is your firm's logo and information, right?" Me, "Yes." His attorney, "And you provided these legal services, right?" Me, "No." A very confused attorney slowly started to put together, after a couple more follow-up questions, that this idiot client of ours had manufactured my invoice to prove his damages. Needless to say that I could have given his new attorney the heads up, but it wasn't going to help someone who had committed perjury to the court using my name. I had represented him in a completely different matter, and this guy was trying to make some extra cash through this bankruptcy hearing. 2 lessons. Tell your attorney everything, and as an attorney, make sure your client feels comfortable to tell you everything. Story 3. Cross-examining a custom home builder who had a lump sum contract, set price as opposed to cost plus, which means the cost of the materials plus X% as builder fee, with the homeowner. Claimed he put 20% more labor or materials into building the home than the contract provided for it, and he was suing for these excess costs. I was asking him about an email with my client negotiating the price of the construction, and he volunteers that he knew he couldn't build it for that price. My head snaps up. My supervising partner's head snaps up. The opposing counsel goes pale. The dialogue was something like this. Me, "You quoted X price?" Builder, "Yes." Me, "You knew you couldn't build it for that price." Builder, "Yes." Me, "You knew the homeowner was relying on that quote." Builder, "Yes." Me, "You knew the homeowner wouldn't have signed the contract without that representation." Builder, "Yes." Me, "And you told homeowner's lender you could do it for X." Builder, "Yes." Me, "And the bank relied on that price and wouldn't have given a loan if they knew it was wrong." Builder, "Yes." This is textbook fraudulent inducement and he had no idea. The builder got poured out in the arbitration award and slapped the builder with sizable punitive damages on top of it. 5 minutes of testimony sunk his case because he volunteered information without being prompted. Story 4. Lady got into a minor fender bender with a truck in a casino parking lot. She backed out of a spot into him. My guy said she parked and went inside the casino for a few hours. At her deposition, she testified that she was so hurt she went right home and to a hospital. I asked if she was a frequent visitor of the casino and if she had a rewards card. She was happy to tell me she did and that she had gold status and showed me the card. I subpoenaed her rewards card records and it showed she was playing slots for hours after the accident. Story 5. I was trying to get a restraining order for a woman in domestic violence court from her son's father. We are presenting testimony and she details a story where he grabbed her arm and slammed it on the tub, breaking her wrist. On the cross, I asked the accused if he ever broke my client's wrist on purpose. His response was, "Fuck yeah, I did.
She was 9 months pregnant and about to smoke crack and wouldn't stop. I tried to grab her arm to get the pipe and protect my unborn son.
Fuck me. She left that detail out in her conversation with me. I guess you can be a bad guy without being a bad guy. Story 6. Plaintiff alleged he was so injured in an auto accident that he couldn't work, do any regular activities, or pick up his young kids. He then posted on his public FB profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea he had posted it. Story 7. Perhaps not my best, but it was recent and pretty good. I represented a guy whose car died in the middle of the freeway at 4 a.m. He put on his hazard lights and called 911 for help. At the same time, an LAPD cop heading to work around the same time in a police unmarked car was driving around 87 to 92 miles per hour. Per our deconstructionist, he doesn't see our guy, strikes him, and causes a major 6-car collision, including overturning an 18-wheeler truck. Police arrive and take photos. LAPD officer claimed our guy did not have his hazard lights on and he was only driving 60 miles per hour. He was trying to put some of the faults on our guy. At the deposition of the investigating officer, she doesn't remember if our guy's hazard lights were on or not. The attorney brings photos from the scene. One of the photos showed my guy's hazard lights on. We were dismissed shortly thereafter. Story 8. Not so much a gotcha as it is the defendant giving themselves up. When I worked for insurance defense, I handled the fraud case where a man reported his Rolex as being stolen. He was adamant that he was at a hotel and it was stolen. He has shown no proof of being in a hotel, so it's flagged. We went through the whole process and finally reached depositions. He gets sworn in and eventually let out that he wasn't at a hotel but rather with his mistress and he had left it at her house. His wife noticed he didn't have it on, so he immediately claims it must have been stolen, etc. This man decided to hire an attorney and go through this whole circus just so his wife wouldn't find out about his affair. Needless to say, the claim was denied. Story 9. Not a lawyer, but when I was in the military, I was accused of something I didn't do. They had to go to court over it. And during court, the prosecutor started to detail this investigation and how they had staked my apartment out for months. They entered into evidence a picture of my apartment, and when they put it up, I looked shocked at my lawyer because it wasn't a picture of my place. It was my ex-wife's apartment, a place I had never lived, never even spent a single night there. I lived in a house, she lived in an apartment. And when my lawyer was asked if she objected to the picture being entered into evidence, she replied, "I don't mind them entering it into evidence as long as they change the listing of it." And when one of the members of the panel, no judge, through member board, asked what was wrong with the listing, she looked at him and said, "That's not his apartment." On top of this, the witness they used against me described going to my house on the night in question, and she named the subdivision where she had visited me. Except that wasn't where I lived either. Also wasn't where the picture they had was either. The case was dismissed, and I was told they requested the witness to return to answer questions about perjury. Story 10. I lived with a guy when we were in our early 20s. He worked for one of those shitty furniture rental places where people without money get furniture. Much of his job was repossessing furniture, and in his spare time he was a skateboarder. He severely hurt his back on the job. They were contesting paying his bills and settling. At one of his mediation dates, they revealed they had hired a private investigator to follow him. They showed him pictures of, quote-unquote, himself at a skate park skating when he was supposed to be home recovering. They asked him to verify it was him. He said no. These doofuses had somehow missed that he had a twin brother that also skated. They eventually settled for what I thought was a very low $70K. He had back pain for years that caused him to gain weight and suffer. In his 30s, he finally had back surgery, and he regretted not doing it 10 years earlier. He said it completely alleviated the pain. Story 11. Had a client accused of leading the cops in a high-speed chase. The cop on the stand estimated he was going 90 miles per hour, but never actually clocked him. Then the cop identified where the chase started with me and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended, about 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. The client got acquitted really quick after that. So the cop did 90 miles per hour to catch up with the client and decided to call it a high-speed pursuit. Gotcha. Story 12. In the first case I ever did, opposing counsel misplaced a copy of my client's driver's license. Rather than admitting his mistake and asking me to rescind it, he filed a motion to compel, claiming we never sent it. Well, I was able to provide proof that we'd sent it to him like 8 months ago, so the judge was rather displeased with his antics. Story 13. Represented a DUI client who swore up and down to me he hadn't been drinking or doing any drugs. The newbie officer had his field training officer with him in the car. The rookie pulls the client over for a tag violation and walks back to the car with the body camera still on. Training officer says, "Get him out for a DUI." And the rookie says, "But he's not intoxicated." To which the reply was, "Do it anyway." Body cam clicks off, turns on 7 minutes later, and they're doing field sobriety exercises on my client. The client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The "oh shit" look from the prosecutor and field training officer when the judge saw the tape. I'll treasure that one. The judge wrote the police chief a letter saying the FTO was dead to him and he denied every search warrant he tried to bring thereafter for being a liar. The client is hopefully still on track with a civil attorney in the lawsuit. I love body cams so very much. Story 14. My client was a woman working at a meat packing plant. Her glove, it would only give her the loose kind because they were cheaper, got caught in the machine and she lost her arm. We sued the owners of the plant for the glove issue. We also sued the machine manufacturer for failing to include the required guard. Then we sued the distributor for being in the chain of the sale but didn't really think they played much of a role. The manufacturer swore they included a handguard and said the plant owner must have used a grinder to take it off. During a deposition of the guy that owned the distribution company, he shows up with the sale documents he was supposed to have turned over weeks before. Turns out there was a note in small print at the bottom he didn't know about that said the sale was without the handguard, which is against the law. I pointed it out and we ended up settling that afternoon with the distributor. The woman got all her medical bills paid, got money for a prosthetic, and got a bunch of pain and suffering damages. Damn. All the money in the world does not replace a lost arm. Story 15. Worked as a paralegal or investigator, working on a trade secrets case involving the manufacture of dental wheels used to grind teeth. Long story, but go with it. Company Alpha was a small family-owned manufacturer that made the best product in the market from a small factory in the middle of nowhere. Sold massive amounts of product because of quality. Its location was remote enough and the owner paid employees so well the employees stayed there forever. All of them had worked there for 30 plus years. When the founder of Company Alpha died, it was sold to the international Company Beta because the kids and grandkids had no interest in the company. Company Beta then closed the old factory and tried to use Company Alpha's formula at their facilities. Company Beta couldn't make the formula work. Now enter Company Charlie. Another international company lost the bid on buying Company Alpha. When Company Charlie heard about the problems Company B was having, they bought the old factory facilities and then rehired the old staff to restart production. All the employees of the old Company Alpha were delighted to have their good-paying jobs back and went straight to work, producing better quality items once again, and Company Charlie's product worked. Company Beta sues Company Charlie for trade secret violation. When you buy a company, you buy its trade secrets. And this company had a bunch. This product was just one part, but the most profitable part of their operation. Thus, Company Charlie, because of their action, was accused of violating the laws governing trade secrets. Company Beta even managed to get a temporary restraining order against Company Charlie in federal court, and Company Charlie had to stop manufacturing at the old plant now owned. This is where I enter the picture. Our firm represented Company Charlie, and I was assigned to interview all the employees. I was in the living room of this delightful older lady in her late 50s that offered me snacks, asked me if I was married, and wanted to set me up with a granddaughter, you name it. Best and funniest interview ever. Then she drops the bomb. I asked her how she knew how to make the product. On my previous interview said so-and-so taught them. She said, from the directions on the wall. Total moment of silence. Directions on the wall? Yes, she said. No one ever looks at me, but there is a board on the wall with the directions. I called the janitor of the facility from her phone, yeah, this is before cell phones, and had him meet me there. He unlocks the place and yep, covered in probably 40 years of dust making it just part of the background, is a board with the entire process on it. Thus, when Company Beta sold the factory, which was eventually purchased by Company Charlie, Company Beta accidentally sold the trade secret to Company Charlie because they abandoned it on the wall. I did serious evidence sourcing on this. The best pictures were of the 65-year-old former janitor knocking the dust off the pages, taking the entire board off the wall, putting it in a paper bag, and sealing it so I never touched it. In every picture, he smiled at the camera. His "fuck you" expression was priceless in every picture. They were so freaking funny. The judge in federal court was laughing his ass off when he heard the detail of what I found to reverse the restraining order. When he opened the bag, he laughed even more. The factory reopened immediately. Companies Beta and Charlie settled by agreeing that they both got to use the trade secret but couldn't sell it to anyone else. What they really figured out was, those little old ladies had slightly changed the formula over the years and slightly made them better over time. Even the formula on the wall didn't work as well as these little ladies did. Story 16. My brother is an attorney. He had a case where the guy said he was permanently disabled from a work accident. At a deposition, my brother overheard the guy talking about getting his house remodeled. He was already spending the money he thought he was getting. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. This was before smartphones, so he drove to Best Buy and bought a video camera, went back, and recorded the guy. He had copies made and sent to the other attorney. The guy dropped the suit and was back at work the following Monday. My brother's client didn't want to pay for the video camera. He saved them thousands of dollars. They eventually paid, but he still gets a little peeved when he talks about it. Story 17. I had a client whose $60K car was ruined by a shop that put in the wrong oil. We couldn't prove it at first. The engine blew up, oil leaked out, and evidence was lost. I subpoenaed their bank records and figured out they bought their oil from Costco. Called Costco and got their prices for the last 2 years. I then worked out the amounts they were spending, did some backhand math, and showed that based on the values, it was impossible they had ever bought the right oil. They settled in full immediately. You've got to admit, it is the most satisfying thing when the opposition caves in immediately when you prove what they're saying is impossible. Story 18. Not a lawyer, but a legal videographer. This gentleman was claiming injuries and seeking damages against his employer after a fall at work. He claimed he couldn't raise his right arm above his shoulder because of the fall. The first deposition comes along, and I'm hired by the defendant's attorney to videotape the deposition of the plaintiff. Does anyone know the first thing a court reporter asks you to do in a deposition?
Please raise your right hand or repeat after me.
Plaintiff raises his right arm above his shoulder with ease and no sign of discomfort. It does not occur to him what he had just done. Both attorneys were looking down at their notes when this happened, and neither of them caught it. The plaintiff himself didn't catch it. The court reporter looked at him and then looked at me, and then her eyes went wide with realization at what just happened. 4 hours of deposition proceed where the plaintiff is instructed, multiple times, to show his range of motion and proceeds to pretend like he can't raise his arm above shoulder level, which he did at the very beginning of his deposition. Deposition ends, plaintiff's counsel leaves. I call defense, hiring party, counsel over, and show him the first 2 minutes of tape. Counsel excitedly whispers to me, "Case closed. You just saved us tens of thousands of dollars." I got a $5,000 bonus and the plaintiff's case was dismissed with prejudice. $5,000 bonus? I should get into legal videography.